The school cafeteria at Maplewood Elementary smelled the way it always did on Friday mornings, like industrial cleaner and the distant ghost of yesterday's pizza, sharp and institutional, the kind of smell that clung to the linoleum floors and the painted cinder block walls and had been there so long it had stopped being a smell and become simply a condition of the air. Outside, the November sky over Clarksville, Tennessee had gone the particular shade of bruised pewter that arrives in the South just before winter makes up its mind, heavy and low and pressing down on everything with a kind of patient inevitability that the locals called brooding and the weather service called a cold front. Inside the cafeteria, it was warm and loud with the particular noise of 400 children who had been sitting quietly in classrooms all morning and were now, for 22 minutes, entirely free. If you're enjoying this story so far, don't forget to hit the like button and subscribe. Drop a comment telling me where in the world you're watching from. I love hearing from you. Danny Reeves was 8 years old, and he was standing in the lunch line with his tray and his $1.75 and his very careful attention to the woman behind the counter. He was small for his age, the kind of small that made adults instinctively soften when they looked at him, with dark brown hair that his father cut every few months at the kitchen table with a pair of scissors that were not quite right for the job, and eyes that were an unusual shade of gray-green, serious and watchful, the eyes of a child who has learned early that paying attention to people's faces tells you things that their words do not. He was wearing his good hoodie, the navy blue one with the white drawstring that his grandmother had sent for his birthday in September, and his sneakers were the ones from last year, the right toe beginning to separate from the sole in a way that he had fixed temporarily and with great optimism using a piece of electrical tape from his father's toolbox. The electrical tape had been holding for 3 weeks now, which Danny considered a personal engineering achievement. His lunch tray held a rectangle of something the menu called shepherd's pie and Danny called questionable, a carton of chocolate milk, an apple, and a dinner roll that he had learned from 9 months of cafeteria experience was always better than it looked. He had $1.75 in his hand, which was exactly the price of the standard lunch. He had checked this morning. He checked every morning carefully, the way his father had taught him to check things quietly and in advance, so that you did not end up surprised in a public place. Danny's father, Ray Reeves, was a man who understood the particular importance of not being surprised in public. He was 34 years old and worked as a shift supervisor at the Clarksville water treatment facility, a job that paid reliably and came with health insurance and required him to be at work at 6 in the morning 3 days a week and 2 in the afternoon the other 2, which meant that Danny took the bus every single morning and let himself in after school every single afternoon with the key he wore on a length of paracord around his neck, tucked inside his shirt where it sat against his sternum like a small warm anchor. Ray Reeves was not a man who complained about his situation. He had a son he loved with a ferocity that was the organizing principle of his entire existence, a modest brick house on Carver Street that he owned outright because his own parents had left it to him, a truck that ran reliably, and a legal situation that had been quietly unraveling his life for the past 14 months. The legal situation was this. 18 months ago, a man named Gerald Fitch had rear-ended Ray's truck at a red light on Highway 41A while running a stop sign and under the influence of prescription medication he had been warned not to drive on. Ray had a fractured wrist, a totaled truck, and 3 weeks of missed work while the wrist healed. Gerald Fitch had excellent legal representation and a documented history of being the kind of man who knew how to make things go sideways in court. The insurance company had lowballed the settlement offer. Ray had hired an attorney on contingency who had turned out to be less capable than his consultation had suggested. The case had dragged. The attorney had withdrawn 6 months in. The new attorney Ray had found had done her best, but the Fitch family had money and patience and a legal team that had extended the proceedings through every available procedural channel until Ray, who did not have money and whose patience had limits defined by a single father's daily reality, was exhausted and nearly broken. The hearing was scheduled for the following Thursday. Ray had told Danny it was a meeting, the way parents tell children simplified versions of things when the full version is too large and too frightening for an 8-year-old to carry. Danny had nodded and accepted the word meeting and filed it quietly in the same internal space where he kept all the things he understood better than his father thought he did. Danny reached the front of the lunch line. The woman behind the counter was named Mrs. Paulette. That was what her name tag said. Mrs. Paulette, in black letters on a white badge, and she was a heavy-set woman in her 50s with silver-streaked hair pinned back from her face and reading glasses on a chain around her neck and the expression of someone who had been standing on her feet since 6 in the morning, and expected to be standing on them until 2 in the afternoon and had decided approximately 30 years ago to be pleasant about it regardless. Danny put his $75 on the counter. Mrs. Paulette ran his tray across the scanner. She looked at the register. Something in her face shifted almost imperceptibly. Not pity, something more careful than pity. She looked at Danny, over the top of her reading glasses. "Sweetie," she said, keeping her voice low, "you're 40 cents short today." Danny looked at the register. He looked at the money in his hand. He had checked this morning. He had absolutely checked. "I thought it was $1.75, he said. "Prices went up at the start of the month," Mrs. Paulette said. "2.15 now. I'm sorry, hon. I should have sent a note home, but the reminders went out late." Danny stood very still. He was doing the particular arithmetic of a child who has been in a tight spot before and knows that the space between what you have and what you need is not a place to panic, but a problem to solve. He looked at his tray. He looked at Mrs. Paulette. He looked at the children behind him in line. "Can I put the shepherd's pie back?" he asked. "And just keep the roll and the milk?" Mrs. Paulette's face did something complicated. "The items are priced as a set, baby. It doesn't work quite like that. Let me just, I got it." The voice came from behind Danny. He turned. The woman standing behind him in line was perhaps 60 years old, possibly older. It was difficult to tell precisely. She was not tall, barely taller than Danny in her practical flat-heeled shoes, and she was dressed with a simplicity that might at first glance have seemed ordinary: dark slacks, a gray wool coat that had seen several winters, a plain leather bag over one shoulder. Her hair was white and cut short, and her face was the face of a woman who had spent a very long time paying attention to things. There was something in her bearing, something in the particular way she stood, that Danny could not have named but registered in the instinctive way children sometimes register things about adults that the adults themselves are not announcing. She had a tray in her hands. She stepped forward beside Danny and placed 2 quarters on the counter with a quiet deliberateness, the way you put something down when you want it to be final and not discussed. "For the young man," she said to Mrs. Paulette. Mrs. Paulette took the quarters. She looked at the woman with an expression of mild surprise that softened quickly into warmth. Danny looked up at the woman. The woman looked down at him. She was not smiling in the ordinary cafeteria stranger way, not the reflexive warmth that adults sometimes aimed at small children without quite seeing them. She was looking at him the way people look at things they are genuinely interested in, with a directness that was not unkind. "Thank you," Danny said. He had been raised by a man who understood that gratitude was not optional. "You didn't have to do that." "No," the woman agreed pleasantly. "I didn't have to." She moved down the counter to collect her own lunch, the shepherd's pie, as it happened, and a cup of tea from the beverage station. Not the standard student lunch, but a tray that the cafeteria offered to staff and visitors. Danny noticed this. He noticed she had made a point of taking the lunch that she had just argued ought not to disqualify him from his full meal. He filed this observation in the same internal space as the other things he was careful about. He carried his tray to his regular table near the window, where his friend Kenji was already halfway through his roll. He sat down. Through the cafeteria's wide windows, he could see the gray November sky over the Maplewood Elementary schoolyard, the bare oak tree at the corner of the fence, and the parking lot beyond where the visitor spaces were mostly empty on a Friday. He thought about the woman. He thought about the way she had said, "I didn't have to," which was not what adults usually said when they did something kind for a child. Adults usually said "of course" or "don't mention it" or "no problem at all," which were all ways of making the kindness smaller. She had said, "I didn't have to," which was a way of making it mean something while keeping it simple. Danny thought this was interesting. He ate his shepherd's pie, which was not as bad as he had been expecting, and thought about it some more. The woman with the white hair and the gray wool coat was not at Maplewood Elementary for the shepherd's pie. Her name was the Honorable Eleanor Voss, and she had been a circuit court judge in Montgomery County, Tennessee for 22 years. She had tried more than 4,000 cases in that time: civil cases, criminal cases, family law, contract disputes, personal injury claims, and every variety of human conflict and miscalculation that could be translated into legal terms and brought before a court. She had a reputation that had accumulated over 2 decades into something that felt, in the Clarksville legal community, less like a reputation and more like a natural feature of the landscape. She was known for three things: her meticulous preparation, her absolute intolerance of procedural manipulation by well-resourced parties against less resourced ones, and a quality that lawyers who appeared before her described variously as perception or as a kind of terrifying accuracy in reading the actual substance of a case underneath its paperwork. She had also been, for the past 2 years, fighting a form of cancer that she had disclosed to her clerk and her fellow judges and precisely no one else in the Clarksville legal community. The treatment was working. The doctors were cautiously optimistic. The cautious optimism had settled into something more solid at her last appointment 3 weeks ago, when the oncologist had used the phrase meaningful remission with the careful precision of a man who did not make promises he could not keep, but was genuinely pleased to be delivering good news. She had not told anyone, partly because she was not a woman who processed things by broadcasting them, and partly because she had a case on her docket for the following Thursday that she had been thinking about for 3 weeks and did not want anyone to suggest she recuse herself from on grounds of diminished capacity that did not apply. She was, if anything, more acutely focused than she had been before the illness. Being very close to something that could have ended her life had the effect, in Eleanor Voss's case, not of making her sentimental or diffuse, but of sharpening everything to a point. The case was Reeves versus Fitch, a personal injury claim arising from a motor vehicle accident 18 months prior. She had reviewed the docket. She had read every filing. She had noted the procedural pattern with the quiet attention of a woman who had been watching legal strategies for long enough to identify them without being told. The Fitch defense team had deployed every available mechanism for delay and attrition continuance requests, discovery disputes, motions to compel that went nowhere, a substitution of counsel filing at the 11-month mark that had bought an additional 60 days. On the other side of the case, a single father with a fractured wrist and a truck he could not afford to replace, who had changed attorneys twice and whose current representation, a competent but overworked attorney named Cheryl Abbott, was doing the best she could with a case that had been ground down by 14 months of procedural warfare. Eleanor Voss had presided over enough cases in 22 years to know the difference between a defendant with a legitimate legal defense and a defendant with a legal team deployed specifically to make the plaintiff too exhausted to continue. She also knew that she could not allow this distinction to operate as a prejudgment. She would hear the case Thursday, examine the evidence, apply the law, and reach the correct conclusion. She had done this 4,000 times. She would do it again. What she had not planned to do, on this particular Friday morning, was visit Maplewood Elementary School. That had been her granddaughter Sophie's doing. Sophie was 7 years old and a first grader at Maplewood, and she had been performing in the school's Veterans Day Assembly that morning a small speaking role in a pageant that involved a poem about service and a felt banner that the first grade class had made together. Eleanor's daughter Miriam had called her 2 nights ago with a combination of hopeful suggestion and carefully modulated pressure that Eleanor recognized as the specific tone of a woman trying to arrange things for her child without demanding. "Mama, if you're feeling up to it, if you wanted to come, it would mean everything to Sophie. She'd love to see you in the audience." Eleanor had gone. Sophie had delivered her 4 lines with the focused gravity of a child who has been practicing in front of a mirror for 2 weeks and found it entirely worth it. Eleanor had sat in the gymnasium on a folding chair and watched her granddaughter speak her 4 lines and felt something in her chest that she had felt more frequently in the past year, a kind of heightened awareness of exactly where she was and who she was looking at, as if the illness had removed a layer of filtering that she hadn't known was there. After the assembly, Miriam had taken Sophie back to class, and Eleanor, who had parked in the visitor lot and was planning to drive directly to the courthouse for a 2 o'clock hearing, had found herself stepping into the cafeteria rather than the parking lot. She was not sure quite why. She had eaten breakfast. She was not hungry. The cafeteria was warm and she was cold, and perhaps that was part of it, but she thought it was also something else, the particular pull of being in a place full of children, which she had not anticipated affecting her the way it did, and which she did not entirely want to rush away from. She had taken a tray and joined the lunch line and found herself standing behind a small boy in a navy blue hoodie, who was counting out exact change with the very careful attention of someone for whom exact change was not a formality. She had heard the exchange with Mrs. Paulette. She had placed 2 quarters on the counter. She had watched the boy look up at her with those gray-green eyes and say, "You didn't have to do that," and she had told him the truth, which was that she hadn't, and which was a thing she found herself saying automatically, The same way she said things in court that she had not pre-planned but that turned out to be precisely correct. Now she was sitting at a table near the faculty coffee station with her shepherd's pie and her tea, and through the cafeteria windows she could see the gray November sky, and she was thinking about Thursday. She was also, if she was honest with herself, and Eleanor Voss was constitutionally, sometimes inconveniently, honest with herself, watching the boy at the window table. Not intrusively. Simply with the attention she brought to anything she found worth understanding. He was eating his lunch and talking to a smaller boy beside him, and whatever he was saying was making the smaller boy laugh, and there was something in the way he leaned forward and gestured with his roll while he talked that suggested a child who was entirely comfortable being someone that other people found interesting. Not performing, simply present. It was a quality Eleanor had spent 22 years watching for in witnesses and plaintiffs and defendants and attorneys, the difference between a person presenting themselves and a person simply being themselves. The boy at the window table was simply being himself, and Eleanor filed this observation in the same careful internal space where she kept everything she considered worth knowing. When she finished her tea, she carried her tray to the return window and put on her coat. She paused for a moment near the cafeteria exit. The boy at the window table caught her eye across the room. He raised one hand in a small, deliberate wave. Not the reflexive wave of a child performing politeness, but something more considered, an acknowledgement, one person to another. Eleanor Voss raised one hand in return. Then she went out to the parking lot and drove to the courthouse, and for the rest of that Friday afternoon, between filings and a 4 o'clock motions hearing in an unrelated civil matter, she thought intermittently about gray-green eyes and electrical tape holding a sneaker together and a child who said you didn't have to do that and seemed to mean it as a genuine observation about the nature of choice. Ray Reeves got home from the afternoon shift at 6:30. The kitchen light was on, which meant Danny was home, had been home since 3:15, had made himself a snack as instructed, had presumably done at least some of his homework, and was almost certainly in the living room with the television on at the exact volume that occupied the specific middle ground between loud enough to enjoy and quiet enough to deny later if asked. All of this turned out to be correct. Ray hung his jacket on the hook by the door and found his son on the couch with a bowl of crackers, a math worksheet that was approximately 60% complete, and a documentary about deep-sea fish on the television at a volume that was technically defensible. "Hey, bud," Ray said. "Hey, Dad." Danny looked up. He had his father's coloring, the dark hair, and the way he held his face when he was thinking carefully about something, a quality of composed attentiveness that Ray had been told repeatedly, by teachers and his own mother and the school counselor who had done Danny's second-grade assessment, was unusual in a child Danny's age, and which Ray privately thought was probably a result of having had to pay close attention to things earlier than most kids needed to. Ray sat down on the other end of the couch and looked at the math worksheet without touching it. It was multiplication. Danny was good at multiplication. The 60% completion rate was not about inability. How was school? Danny considered this with the brief, genuine consideration he brought to most questions. "Good," he said. "I was 40 cents short at lunch." Ray felt the familiar small tightening in his chest that had become a background condition of the past 14 months. "I thought it was $1.75. Prices went up. It's $2.15 now." Danny turned a cracker over in his hand. "A woman paid the difference for me." "What kind of woman?" "Old. White hair. She was there for the Veterans Day thing, I think. She had a visitor badge." Ray nodded slowly. "Did you thank her?" "Yes." Danny looked at him with the particular expression he wore when the answer to a question was very obvious. "She said she didn't have to do it." "She didn't." "That's what I said." Ray reached over and ruffled his son's hair, which Danny tolerated with the resigned patience of a child who has accepted that this was going to keep happening regardless of his opinions about it. "Finish your worksheet," Ray said. "I'll make dinner." He went to the kitchen. He stood at the counter for a moment with his hands flat on the surface and his eyes on the window above the sink where the darkness had settled in fully now, and the streetlight at the corner of Carver made a pale orange bloom against the glass. Thursday was 6 days away. He had reviewed everything with Cheryl Abbott last week. The evidence was clear: the police report, the witness statements, the medical records, the documentation of the lost wages. The accident had not been his fault by any measure. The law was, he had been told, on his side. The problem was that the law being on your side and the law doing what it was supposed to do were two things that experience had taught him were not reliably the same. Gerald Fitch's attorney was a man named Warren Caldwell, a partner at one of Nashville's larger firms, a man whose suits cost more than Ray's monthly mortgage payment and who had spent 14 months making this case as expensive and as exhausting as possible with the precise and calculated intention of making Ray Reeves give up. Ray had not given up, but he was tired in a way that had settled into his bones, the specific exhaustion of a man who has been paying attention to something threatening for a very long time without being able to make it stop. He thought about Danny's 40 cents. He thought about the woman who had placed 2 quarters on the counter and said, "I didn't have to." He started making dinner. Pasta. Simple. The kind he could do without thinking about it, which left his mind free to go over the same ground it had been going over for 14 months, the evidence, the timeline, the hearing, the outcome that was supposed to be obvious but had been made as unclear as possible by people with enough money to make clarity optional. From the living room, he could hear the television and the scratch of Danny's pencil completing the remaining 40% of the multiplication worksheet, and underneath both of those sounds, the familiar sound of his son being reliably, steadily fine in the particular way that Danny was always fine, which was a quality Ray was grateful for every single day, and which sometimes in quiet moments like this one cost him something that he could not quite name. He stirred the pasta. He watched the water. He thought about Thursday. The Clarksville courthouse occupied a solid limestone building on Commerce Street, 3 stories of institutional permanence that communicated something Ray had always thought was both reassuring and faintly threatening: the permanence of the system, which was sometimes your ally and sometimes simply the weight of the thing bearing down on you. He had been inside it 6 times in the past 14 months, each time in the company of an attorney with organized files and measured optimism, each time leaving with the case still unresolved and his confidence in resolution slightly smaller. Cheryl Abbott met him at the bottom of the courthouse steps at 8:45 Thursday morning. She was 41 years old, a compact woman with reading glasses pushed up on her head and a litigation bag over one shoulder, wearing the expression she always wore when they were about to go into a hearing, focused and honest and carefully controlled. Cheryl Abbott's greatest quality, Ray had come to understand, was that she did not manufacture confidence she did not feel. She told him the truth in precise language and let him make of it what he could. He had come to value this more than almost anything. "How are you feeling?" she asked. "Ready to be done with it," Ray said. "That's fair." She looked at her files. "We've got Hutchinson on the accident reconstruction and Dr. Patel's sworn statement on the wrist. The financial documentation of the lost wages is solid. The Fitch team is going to try to argue comparative fault, which the police report does not support, but they're going to try it anyway." She looked up at him. "Judge Voss is known for not letting procedural theater substitute for substance. That's favorable." Ray nodded. He held the door and they went inside. The courtroom was on the 2nd floor, a room with high ceilings and the good clean acoustic silence of a space where things were taken seriously. Fluorescent lighting overhead, rows of wooden benches, the raised bench at the front where the judge would sit. Warren Caldwell was already at the defense table with 2 associates and the general atmosphere of a man who considers Thursday hearings a minor professional obligation rather than a significant occasion. Gerald Fitch sat beside him in a gray suit, a man of 50 with heavy-lidded eyes and the slightly pouched look of someone whose comfort had always been adequately funded, looking across the room at Ray with the expression of a man who does not believe the person across from him is going to turn out to be a serious problem. Ray sat down next to Cheryl and looked at the bench. The bench was empty. The judge had not yet arrived. The bailiff called the room to order at 9 sharp, and Eleanor Voss came through the door to the left of the bench in her robes and took her seat with the unhurried efficiency of a woman who has done this many thousands of times and is neither impressed by the ceremony nor dismissive of it. She arranged her materials. She put on her reading glasses. She looked at the room. Ray looked at the judge. Something happened in his chest that was difficult to name. Not recognition exactly. He had never met Judge Eleanor Voss, had only seen her name on court documents and heard her described by Cheryl in the careful language of an attorney characterizing a jurist, but something adjacent to recognition, the specific sensation of looking at someone and understanding immediately, on some level below articulation, that they are going to see the actual thing. He had not expected this. He had expected competence. He had expected fairness, or at least its procedural approximation. He had not expected to look at the judge and feel, and this was not a rational response. He understood this. It was the response of a man who had been exhausted for 14 months and was sitting in a courtroom at 9 in the morning trying very hard not to need anything to be true that might not be true. He had not expected to feel that this woman was going to look directly at what had actually happened. Judge Voss reviewed her materials for approximately 30 seconds. Then she looked up. Her gaze moved across the room with the economy of someone who has learned to see what they need in a single pass and not waste effort on what they don't. It passed over Warren Caldwell's table, registered something there without expression. Passed over Cheryl Abbott and Ray. It settled for a fraction of a second on Ray's face, or perhaps he imagined this. He could not be certain before moving on. "We're here on Reeves versus Fitch," she said. Her voice was not loud. It did not need to be. "I've reviewed every filing in this matter. I want to make something clear at the outset." She paused. Not dramatically. Simply to ensure she had the full attention of every person in the room. This court is not interested in repetition of arguments that have already been adequately established in the record. What I need from counsel today is substance, specifically anything that has not been said before and that has a direct bearing on the core question, which is what happened at the intersection of Highway 41A and Trenton Road on the morning of September 17, 18 months ago, and who bears responsibility for it. Warren Caldwell, Ray noticed, shifted slightly in his chair. He did not say anything. He made a note on his legal pad. The two associates beside him exchanged a glance that was brief and almost invisible. Cheryl, beside Ray, uncapped her pen. Something in the room had changed. Not dramatically. Simply the particular quality of the air when a person in authority makes clear, without raising their voice, that the rules of engagement are going to be different than the previous 14 months of proceedings may have suggested. Ray Reeves sat very still in his chair and breathed carefully through his nose and thought about Danny at home at Maplewood Elementary right now in his navy blue hoodie and his sneaker with the electrical tape, and he thought about 14 months, and he thought about Thursday finally being here, and he waited. He did not know, could not know that the judge looking at the papers in front of her had also been thinking, in the practiced, compartmentalized way that 22 years had taught her to think about multiple things at the appropriate time and place, about a small boy in a cafeteria raising his hand in a deliberate wave across a busy room. She did not know it was the same boy. She could not have known. The name on the case was Reeves. She had not known Danny's last name. She had not asked. She had placed 2 quarters on a counter and told an 8-year-old the simple truth that she hadn't had to, and driven to the courthouse and prepared for Thursday, and thought nothing more about it in a way that would have connected the boy at the window table to the man sitting now at the plaintiff's table with his hands folded and his jaw set, and the look of someone who has been waiting a very long time for something that ought to have been simple. The hearing proceeded. Cheryl Abbott presented the reconstruction testimony first, the accident analyst named Hutchinson, who had a talent for reducing physics to language that a person who was not an engineer could follow. The Fitch vehicle had been traveling at an estimated 42 miles per hour, approaching a red light. The deceleration profile of the Reeves vehicle indicated that Ray had been stopped for between 3 and 4 seconds before impact. The skid marks, or rather their absence, indicated no braking by the Fitch vehicle before collision. Warren Caldwell cross-examined with the professional thoroughness of a man who has handled enough accident cases to know exactly which variables to probe for ambiguity. He got some of what he was looking for. He did not get as much as he would have gotten in front of a different bench. Twice, Judge Voss interrupted Caldwell's cross-examination not to rule against him, but to ask clarifying questions of the witness herself. Precise, technical questions about the methodology of the reconstruction, delivered with the exactness of someone who had done enough research on the subject before Thursday to know what she was asking. Hutchinson answered her directly, and without the defensive qualification he had brought to Caldwell's questions. The judge nodded and made a note and let Caldwell continue. Ray watched this happen and felt the 14 months begin, very slightly, to shift in him. Not resolve. Not yet, but shift. At 11:15, Judge Voss called a 20-minute recess. Ray stood up from the table and stretched carefully his wrist, the one that had been fractured and had healed incompletely in the way of injuries that didn't get the physical therapy they needed because the plaintiff couldn't afford the copays, and found Cheryl at his elbow. "She's paying attention," Cheryl said quietly. "I can see that. Caldwell knows it too." Cheryl glanced toward the defense table, where Warren Caldwell was in close conversation with one of his associates, his back to the room, his voice below audible range. He's recalibrating. That's good for us. They went out into the hallway. Ray stood at the tall window at the end of the corridor that looked out over Commerce Street, where the November morning had gone from gray to a thin, washed-out brightness, winter light with no warmth in it but a surprising clarity. He could see the diner across the street, the hardware store, the parking garage on the corner where he'd parked his truck. His phone had a text from Danny, sent 20 minutes ago. "How is it going?" With no question mark, because Danny never used question marks in texts, which was a grammatical habit Ray had decided he would address when the current legal situation was resolved and he had bandwidth for small corrections. He typed back, "Okay so far. Good judge. Let me know if you need anything." 3 dots appeared immediately, then, "Okay. There is a substitute in math, but she seems fine." Ray smiled at his phone, put it back in his pocket, looked at the street. He thought about what Cheryl had said. Good judge. He had been told this before. He had been told the law was on his side before. He had learned 14 months ago that being told a thing and the thing being true in the way that mattered were 2 different categories of information. But he had also learned in the same 14 months that you had to keep showing up, that you had to keep standing in the place where the truth was and pointing at it clearly, and trust that the person with the authority to see it would eventually look. He went back inside when the recess ended. Judge Voss resumed the bench with the same measured unhurry with which she had taken it at 9 o'clock. She looked at the room. She looked at her notes. "Before we continue," she said, "I want to address the motion filed by the defense on October 9th requesting exclusion of the wage documentation on grounds of insufficient employer verification." Warren Caldwell straightened slightly. "I've reviewed that motion and I'm going to deny it," Judge Voss said. Her voice was even. "The documentation is properly certified by the employer's HR department and consistent with the tax records in evidence. The motion reads as an attempt to narrow the damages calculation in the absence of a legitimate evidentiary basis for doing so." She paused. "I want to be clear about something, Mr. Caldwell. This court is aware of the procedural history of this case. I am not going to characterize past filings, but I want to be equally clear that we are done with procedural questions today. We are going to decide this case on its facts." The room was very quiet. Warren Caldwell said, "Understood, Your Honor." He said it with the precise, controlled professional courtesy of a man absorbing something he did not like and has decided not to argue with. Ray, watching him say it, understood for the first time in 14 months that the ground had shifted. He folded his hands on the table. He breathed. He waited. And somewhere in the back of his mind, entirely disconnected from the legal proceeding that was about to conclude in the way it should have concluded 14 months ago, he thought about Danny coming home from school with his 40 cents and the woman who had paid them without ceremony and said, "I didn't have to," and he thought that some things were connected in ways you couldn't trace and some kindnesses landed in places they were never aimed at, and that sometimes the world, in its thoroughly unreliable and occasional way, pointed in the right direction after all. The afternoon session began at 1:15. Warren Caldwell presented the defense's case with the polished efficiency of a man who had spent 14 months constructing a particular version of events and was now delivering it for what he clearly intended to be the final time. He called Gerald Fitch to the stand. Fitch was a careful witness. Ray could see that immediately. He had been prepared extensively, expensively prepared, and he gave his testimony in the measured cadence of someone who has rehearsed not just the words but the pace and the register of them, the specific vocal quality of a man being truthful. He described the accident with the particular fog of memory that made everything slightly uncertain without being specifically wrong. He said he thought the light may have been yellow. He said the roads were wet. He said he remembered braking. He said everything with the earnest, slightly sorrowful expression of a man who deeply regrets what happened and has spent 18 months thinking about it. Ray listened to all of it with his hands flat on the table and his jaw set. Cheryl's cross-examination of Fitch was methodical and calm. She walked him back through the police report which said yellow nowhere. She walked him through the witness statement from a retired teacher named Mrs. Carolyn Briggs who had been sitting at that red light in the adjacent lane and had described in writing, on the day of the accident, a blue sedan traveling at high speed through a red light with no apparent braking before impact. She walked Gerald Fitch through each of these documents with the patient, unperturbed attention of a woman who knows exactly where she is going and is not in any hurry to get there. Fitch maintained his composure throughout. He was good at it. He had the particular resilience of a man who has had to maintain a version of reality against contrary evidence before and has found that consistency, delivered with the right expression, does significant work in a room. Judge Voss watched him with the same quality of attention she had brought to everything since 9 o'clock that morning. She did not interrupt the cross-examination. She made notes. When Cheryl finished, she looked at Fitch over the top of her reading glasses. "Mr. Fitch," she said, "you testified that you believed the light may have been yellow. Is that correct?" "Yes, Your Honor. I'm not entirely certain, but I believe the police report on page 7, line 4, documents a traffic signal cycle time of 90 seconds at that intersection, with a yellow phase of 4 seconds. She looked at her notes. The reconstruction testimony established that your vehicle was traveling at approximately 42 miles per hour approaching the intersection. At that speed, your stopping distance in dry conditions would have been approximately 120 feet. The road, as you noted, was wet. Your stopping distance was therefore greater. She paused. A 4-second yellow phase at 42 miles per hour and wet road conditions means that you would have needed to begin braking approximately 200 feet from the intersection to stop within the yellow. The reconstruction found no skid marks consistent with emergency braking at any point approaching the intersection. Another pause. So what I want to understand is this. In your estimation, how is it possible that the light was yellow when you entered the intersection? The courtroom was silent. Warren Caldwell said, "Objection, Your Honor. The court is testifying." "The court is asking a clarifying question of your client, Mr. Caldwell, which is within its authority." Judge Voss kept her eyes on Fitch. "Mr. Fitch." Fitch looked at Caldwell. Caldwell gave him nothing. He looked back at the judge. "I may be misremembering," he said. "You may be," Judge Voss agreed. Her voice was even and gave nothing away. "You may step down." Caldwell's closing argument took 22 minutes. It was well-constructed and professionally delivered, and it made the best possible case for a set of facts that the morning's testimony had not supported. Ray listened to it and felt no particular alarm, which itself felt significant. For 14 months, every filing, every continuance, every procedural maneuver had carried a low electrical charge of anxiety. He did not feel it now. He was not sure precisely when it had left him. Cheryl's closing was 12 minutes. She stayed close to the evidence. She let the reconstruction numbers speak. She reminded the court of Mrs. Carolyn Briggs and her statement written on the day of the accident when the memory was immediate and unprocessed, before any attorney had the opportunity to suggest uncertainty where there had been none. She thanked the court for its time. She sat down. Judge Voss reviewed her notes for approximately 90 seconds. The room was silent in the particular way of people who have decided that making any noise at all would be inappropriate. Then she looked up. "In 14 months of docket history on this matter," she said, "this court has received 11 filings from the defense. Of those 11, 9 were procedural in nature and generated no substantive legal resolution. The 2 substantive filings, the comparative fault motion and the wage documentation exclusion motion, have both been disposed of today." She set her pen down. "The facts of this case are not ambiguous. A motor vehicle operated by the defendant entered an intersection against a red traffic signal at a speed inconsistent with safe stopping in the prevailing road conditions and struck the stationary vehicle of the plaintiff, who had been stopped for a documented 3 to 4 seconds prior to impact. The plaintiff sustained a documented fracture of the right wrist, lost 3 weeks of employment income, and incurred the total loss of his vehicle. The defendant's operation of his vehicle on that morning, while using prescription medication he had been medically advised not to drive on, a fact documented in the medical records entered into evidence and not disputed, constitutes negligence per se under Tennessee law." She paused. Ray's hands, still flat on the table, were pressing hard against the surface without his entirely intending it. "The court finds in favor of the plaintiff," she said. "Damages are awarded as follows: medical expenses as documented, in full; lost wages as documented, in full; vehicle replacement value as assessed in the submitted appraisal, in full. Pain and suffering, taking into account the nature of the injury, the incomplete recovery documented in Dr. Patel's sworn statement, and the duration of this proceeding which has itself constituted a significant burden on the plaintiff, the court awards an additional sum of $18,000. She looked at Caldwell. Mr. Caldwell, the court is also taking note of the procedural history of this case for purposes of a separate cost determination. You will receive that in writing within 10 days. Warren Caldwell said nothing. He wrote something on his legal pad with the careful, controlled movement of a man keeping his expression neutral by occupying his hands. Gerald Fitch stared at the table. Cheryl Abbott turned to Ray. Her face was doing what Ray recognized from 6 previous hearings, as Cheryl Abbott allowing herself to be professionally satisfied, which meant a very slight easing around the eyes and a quality of stillness that was different from her working stillness. "That's it," she said quietly. "It's done." Ray sat with that for a moment. Done. 14 months. 11 filings. 2 attorneys. 3 weeks of a fractured wrist healing wrong because the physical therapy was too expensive. 3 weeks of Danny taking the bus and letting himself in and making his own after-school snack while his father worked extra shifts to cover the bills that kept coming while the case kept not resolving. All of it, compressed now into 2 syllables. "Thank you," he said to Cheryl. His voice was steady. He had been holding it steady for 14 months and he was very good at it. "You held on," she said. "That mattered." He nodded. He gathered his documents. He shook Cheryl's hand properly. 2 hands, the way his father had taught him. He did not look at the defense table. He did not need to. He walked out of the courtroom into the second-floor corridor and stood at the window that looked out over Commerce Street and felt the November light on his face through the glass, thin and clear and entirely without warmth, and did not try to make himself feel anything other than exactly what he felt, which was something between relief and exhaustion that was too large and too mixed to have a name, and which he allowed to move through him without organizing it or managing it or directing it toward any particular purpose. His phone was in his pocket. He did not take it out yet. He thought about Danny at Maplewood Elementary in his navy hoodie and his electrical tape sneaker, sitting in a classroom right now doing whatever Friday afternoon in 3rd grade involved. He thought about the 40 cents. He thought about a white-haired woman placing 2 quarters on a cafeteria counter with the quiet finality of someone making a decision that has already been made. He thought, "I need to tell Danny." He took out his phone and sent a text. "We won. Bud. Come straight home after school. I'm bringing dinner." 3 dots appeared within 30 seconds. Then, "Really? Then how much did we win then? Can we get the good pizza?" Ray laughed. It came out differently than his usual laugh, rougher at the edges, and he pressed the back of his hand against his mouth for a moment and breathed through his nose and let it pass. "Yes," he typed. "Good pizza. I'll explain everything tonight." He put the phone back in his pocket. He picked up his briefcase. He went down the stairs and through the limestone lobby and out the front door of the Clarksville courthouse into the thin November brightness. He did not know, walking to his truck, that Judge Eleanor Voss was standing at her chamber's window on the 3rd floor watching the street below with a cup of tea going cold in her hand, thinking about 14 months and 11 procedural filings and a man who had sat at the plaintiff's table for 5 hours with his hands flat on the surface and his jaw set and had never once looked like he was going to stop. She did not know it was the same man whose son had given her a deliberate wave across a school cafeteria 4 days ago. She would not know this for another 3 weeks. The pizza was from Rosario's on Main Street, which was unambiguously the good pizza, distinguishable from all other pizza in Clarksville by a combination of a wood-fired oven and a sauce recipe that the owner, Marco Rosario, had been declining to share with anyone for 26 years. Ray ordered a large pepperoni and a large margarita and a 2-liter of root beer, which was the specific combination that Danny had identified, at age 5, as the ideal celebratory meal and had not revised since. They ate at the kitchen table. Ray explained everything in the careful, honest language he used with Danny when the thing being explained was something that required the full version, the reconstruction testimony, what the judge had said about the comparative fault motion, the damages award, all of it. Danny listened with the focused attention he brought to everything he considered worth understanding. He asked 2 questions. What is negligence per se, which Ray answered with the care it deserved, and how much does the truck replacement cover, which Ray answered with a number that made Danny nod with the satisfaction of someone who has been quietly tracking a problem and is pleased to see it resolve. What was the judge like? Danny asked. Ray thought about it. She paid attention, he said. She read everything before she came in. She didn't let them do what they'd been doing for 14 months. He took a piece of margarita. She asked Fitch a question he couldn't answer right. Danny was quiet for a moment, eating his pizza with the methodical attention he brought to meals he was enjoying. Then he said, "The woman in the cafeteria. The one who paid my 40 cents. She had white hair." Ray looked at his son. "She was at school for the Veterans Day thing," Danny said. "She had a visitor badge. She was old. She was real quiet, but she looked at things a specific way." He considered this. Like she was going to remember them. Ray set his pizza down. The silence in the kitchen had a particular quality. "You think she was the judge?" Ray said. Not a question. He was watching his son's face, which had the expression it always had when Danny had been carrying an observation for a while and had finally found the right moment to deliver it. "I don't know," Danny said honestly. "I didn't know her name. She didn't say." He looked at his father. "But she paid my 40 cents and she said she didn't have to. And then 4 days later a judge who pays attention won your case." He shrugged with the elaborate casualness of an 8-year-old trying not to overstate something. "I thought it was a thing you might want to know about." Ray was quiet for a long time. He thought about the way the world worked, or the way it sometimes appeared to work, the invisible threads between unconnected moments that you could only see in retrospect, looking backward from the place where things had resolved. He did not believe in the mechanical version of karma, the transactional ledger where one good act reliably purchased one good outcome. He was a practical man who had spent 14 months learning that the world did not run on simple equations. But he thought about 40 cents. He thought about 2 quarters placed on a counter by a woman who could have looked away and did not. He thought about the judge in Courtroom 214 who had read 11 filings before she walked in and had asked Gerald Fitch a question he couldn't answer and had said the word done in a way that made 14 months close like a door. "What did she look like?" he said. "The woman at school." "Short," Danny said. "White hair, cut close. Gray coat, the wool kind. She had a bag over one shoulder. She ordered the shepherd's pie." A pause. "She waved at me when she left." Ray picked up his pizza. He chewed it. He thought, "If it was her," he said carefully, "she wouldn't have known it was connected. She wouldn't have known whose kid you were." "I know," Danny said. "So it wouldn't have been it wasn't like she did it because she was going to decide your dad's case." "I know that," Danny said, with the slightly patient tone he used when his father was working toward a conclusion Danny had already reached. "She did it because I was 40 cents short." He looked at his father. "That's the whole point of it." Ray looked at his son across the kitchen table with the Rosario's pizza between them and the root beer and the ordinary warm kitchen light and felt something he did not have the exact word for, something between pride and tenderness and the particular astonishment that comes from watching a child understand something important and finding that they understand it better than you do. "Yeah," he said. "That's the whole point of it." They finished the pizza. They watched television for an hour. A nature documentary about migration patterns that Danny had been following for 3 episodes, and that Ray found himself genuinely interested in by the 3rd act. Danny fell asleep on the couch at 9:15, which Ray registered with the specific quiet gratitude of a parent watching a child sleep in the uncomplicated way of someone who is simply tired and safe. He carried Danny to his bed. He stood in the doorway for a moment in the dark. Then he went back to the kitchen and sat at the table with his hands around a glass of water and thought about everything and nothing for a while, and then he went to bed too, and slept more deeply than he had slept in 14 months, and did not dream of anything he could remember in the morning. The letter came 10 days after the hearing. It was from the court, as Ray had expected, detailing the cost determination that Judge Voss had mentioned from the bench. He read it at the kitchen table before Danny was awake, with his coffee and the thin December morning starting up outside the window. The letter was precise and formal and stated in the measured language of official legal communication that the court had reviewed the procedural history of Reeves versus Fitch and had determined that the pattern of filings by the defense constituted an unreasonable multiplication of proceedings without substantive legal basis, for which the defendant's counsel was liable for a portion of the plaintiff's legal fees over the 14-month period. Ray read this paragraph twice. He set the letter down. He drank his coffee. He thought about Cheryl Abbott, who was going to be very pleased. He called her at 8:30. She was already at her desk. "I saw it last night," she said. "She doesn't do that lightly." She reviewed every filing individually and made a specific finding. A brief pause. "Ray, in 14 months of watching what they did to this case, this is the part that I am going to be thinking about for a while." "What do you mean?" "She named it for what it was," Cheryl said. "Not in language that gives them room to argue around it. In language that is on the record permanently." Another pause. "You held on long enough for the right person to see it. I want you to know that mattered." Ray thanked her and ended the call and sat for a moment with his phone on the table and the letter beside it and the winter light coming through the kitchen window. He had been thinking for 10 days about Danny's observation. The white hair, the gray wool coat, the visitor badge, the shepherd's pie. He had turned it over the way he turned over things he could not entirely verify but also could not entirely dismiss, with the patient, practical attention of a man who does not make claims he can't support but also does not pretend he hasn't noticed what he's noticed. He had not done anything about it. There was nothing specific to do. He did not know the judge's name from the cafeteria. He did not know if it was the same person. He had no way to find out that did not involve walking into the courthouse and asking questions that would sound, in the asking, like exactly the kind of thing you should not say to a circuit court judge. He had let it sit. He had let it be what Danny had said it was, a thing he might want to know about. He had thought about it in the mornings and at night and during the drive to work and the drive home, and he had not resolved it into anything concrete, but he had also found that thinking about it, the possibility of it, the idea that 2 quarters and a deliberate wave and a woman who paid attention had been in the same week as 14 months ending did something specific to the part of him that had been ground down the longest. It made it easier to breathe. That was the only way he could put it. Not because it proved anything. Simply because it was the kind of thing that, whether or not it was literally connected, belonged in the same category as the thing he needed to believe, which was that showing up in the right place with the right intention eventually, in some form, mattered. Danny came downstairs at 7:40 in his pajamas with his hair going sideways, which was its default state before the morning's intervention. He saw the letter on the table. "Is that from the court?" "Yeah." Ray slid it toward him. Danny sat down and read it. He read slowly and with care, the way he read everything that he considered worth understanding. When he finished, he slid it back. "That's the procedural history part," he said. "You know what that means?" "You explained what procedural means." Danny poured himself cereal. "It means they did things on purpose to make it take longer. Right? And she said so." Danny considered this while pouring his milk. "In writing. In the permanent record, yeah." Danny was quiet for a moment, eating his cereal with the focused attention of someone doing 2 things at once. Then he said, "I want to write her a note." Ray looked at his son. "The woman from the cafeteria," Danny said. "Whether she's the judge or not. I want to write her a thank you note for the 40 cents. He looked up. "That's just the right thing to do." Ray was quiet for a moment. There was a version of this conversation where he explained to his son that they didn't know who the woman was, that finding a circuit court judge to send a thank you note to was complicated, that the appropriate professional and personal distances involved in such a thing were genuinely difficult to navigate. He could hear this version clearly in his mind. He also looked at his son, who was 8 years old and had spent 10 days holding an observation carefully until the right moment, and who was now telling him that the right thing to do was write a thank you note, and who was correct. "Let's figure out how," Ray said. "If you're hooked on this story, make sure to subscribe and turn on notifications so you never miss an upload. Your support means everything and helps me bring you more emotional stories like this one." Cheryl Abbott, when Ray called her, was quiet for a long moment and then said, "I want to be precise about this, because the line between appropriate and inappropriate communication with a judge whose case has concluded is real, and I want to be on the right side of it." Another pause. "A case is concluded. There is no pending matter. A member of the public wishing to express gratitude for the manner in which a public official discharged their duties is not an ex parte communication. That is a citizen communication." A brief silence. You would send it to the court's administrative office. Standard mail. You would not reference the case by name or number. You would not say anything that could be construed as attempting to establish an ongoing relationship. She paused. And if your son wants to write it himself in his own words, that is probably the most appropriate form it can take. Ray relayed this to Danny that evening. Danny considered it with the gravity he brought to logistics he considered important. Can I use my good paper? Ray did not know they had good paper. Apparently they did. A small stack of cream-colored notepaper that had been in the desk drawer since before Ray could remember, possibly since his mother had been alive, the kind with a slight texture that felt different under a pen. Danny sat at the kitchen table with the good paper and a pen, his best pen, the black one with the fine point that he used for what he called important writing, and wrote for approximately 20 minutes. He did not ask for help. He did not read it aloud while he was writing. When he finished, he folded it in thirds with careful precision and said, "Can you read it before I seal it? Just to check." Ray read it. It was 12 sentences. It began, "Dear Judge," or "whoever you are," which Ray thought he might suggest adjusting, and then decided he would not because the honesty of it was more important than the polish. It described the cafeteria encounter in plain, accurate language. It said that 40 cents was not very much money, but that the way she had done it, putting the quarters down without making it a whole thing, had been the right way. It said that his dad's case had been decided fairly this week by a judge who paid attention, and that the description made him think of her, and that maybe it was the same person and maybe it was not, but either way she should know that the 40 cents had been noticed and was appreciated. It said thank you in the direct, unambiguous way of a child who has been taught that gratitude is not optional. The last line said, "I waved at you when you left and you waved back," which I think was a good way to end that part. Ray folded it back along its creases. He handed it back to Danny. "It's good," he said. "Should I change the beginning part?" "No," Ray said. "Leave it exactly as it is." The letter went into an envelope addressed to the administrative office of the Montgomery County Circuit Court. Attention. Judge's Chambers, 3rd floor, with no case reference and no return address beyond Ray's name on Carver Street. It went into the mailbox the following morning. Danny pressed the flag up with the finality of a child who has done something he considers complete. They drove to school. Danny got out with his backpack and his navy hoodie and walked through the front gate of Maplewood Elementary with the particular walk of a child who has put something into motion and is satisfied with the putting. Ray drove to work. He did not know, could not have known, that 11 days later, on a Tuesday afternoon in December, Eleanor Voss would be sitting at her desk after a long morning of hearings, opening the routine mail that her clerk Damon sorted and left in the inbox every afternoon, and that she would reach a cream-colored envelope with a child's careful handwriting on the front, and that she would open it and read 12 sentences, and reach the line that said, "I waved at you when you left and you waved back," which I think was a good way to end that part, and that she would sit very still in her chambers for a long time with the letter in her hands. She would think about the cafeteria. She would think about the 40 cents. She would think about gray-green eyes and a deliberate wave across a busy room. She would think about a man at a plaintiff's table with his hands flat on the surface and his jaw set, and she would think about the name Reeves, which was on the letter and on the docket, and she would put these two things together the way you put two pieces together when you have been looking at them separately and suddenly understand the shape they make. She would sit with this for a long time. Eleanor Voss had presided over 4,000 cases. She had seen evidence that moved her and arguments that impressed her and moments of genuine human quality that she had noted privately and never commented on. She was not a woman given to sentiment in the conventional sense. She was a woman given to precision and to the honest assessment of things, and what she was doing now, sitting at her desk in December with a child's letter on good paper in her hands, was precisely that, assessing honestly the thing in front of her. The boy had been 40 cents short at a lunch counter. He had offered to put back the part of his meal he could do without not whining, not performing distress, simply problem-solving with the dignified practicality of someone who has done this before. He had accepted her 2 quarters without embarrassment and without excess gratitude, and he had said you didn't have to, which was not a complaint or a plea but simply a true and careful statement about the nature of the moment. He had waved. She had waved back. And now, 11 days after a case concluded, he had written her a thank-you note on his good paper with his best pen, and the letter had found her on a Tuesday afternoon in December, and she was sitting with it in the specific way she sat with things that she found worth understanding. She picked up her pen. She opened her desk drawer. She found the notepaper she used for personal correspondence. Plain white with her initials at the top, E. M. V. Embossed in a modest navy blue. She wrote one paragraph. She read it back. She folded it. She addressed the envelope to Danny Reeves on Carver Street. Then she did something she had not done in 22 years of circuit court work. She picked up the phone and called the administrative office downstairs. "I need to know if there's a standard process," she said to the clerk, "for a judge to acknowledge a communication received from a member of the public after a case has concluded." A pause. "Not in reference to the case. In reference to an unrelated personal matter." The clerk, who had worked with Eleanor Voss for 9 years and was therefore not easily surprised by her, thought about it for a moment and said that as long as the communication made no reference to the case or to any related legal matter, it was at the judge's discretion, as a private citizen exercising ordinary social courtesy. Eleanor thanked her and ended the call. She picked up the envelope with Danny's address on it and held it for a moment. Then she walked it down the hall to the outgoing mail herself, which was not a thing she typically did, and put it in the slot and went back to her afternoon. The letter arrived at Carver Street on a Thursday. Danny got it out of the mailbox when he came home from school. He recognized the return address, the courthouse, and recognized the initials on the notepaper when he opened it, E. M. V. and read the paragraph inside with the focused attention of someone reading something they have been waiting for without quite knowing they were waiting for it. He read it twice. He folded it carefully. He put it in the desk drawer in his room in the back where he kept the things he considered worth keeping. He did not tell his father about it that afternoon. He was thinking about it. He needed to think about it for a while first. That evening after dinner, while Ray was doing the dishes, Danny came and stood in the kitchen doorway. "She wrote back," he said. Ray turned around. Danny held out the letter. Ray dried his hands on the dish towel. He took it. He read it once. Then he read it again more slowly. The paragraph said this: "Dear Danny, thank you for your letter, which arrived on my desk on a Tuesday afternoon and which I read with great care. You were right that I was at Maplewood Elementary for the Veterans Day program. I was there to watch my granddaughter. I am glad the 40 cents arrived when it was needed. What I would like you to know is that you handled yourself with a dignity that is rarer than you might expect, and that the wave at the end was indeed a good way to finish that part. I hope your father's case resolved in the way it deserved to. With respect and good wishes, E. M. V." Ray stood at the sink with the dish towel in his hand and read the letter a third time. He thought about 4,000 cases and a woman who had been fighting a cancer she hadn't told anyone about and had come to a school cafeteria on a Friday morning to watch her granddaughter say 4 lines in a pageant. He thought about a cold front coming through Clarksville and the smell of industrial cleaner and the specific silence of a checkout line when a child is 40 cents short. He thought about the 40 cents. 2 quarters. The smallest possible unit of ordinary human kindness, placed on a counter without ceremony by a woman who noticed and had the choice to look away and didn't. He thought about everything that had come afterward. The hearing. The judge who read 11 filings before she walked in. The question Fitch couldn't answer. The permanent record. The letter to the administrative office. The cream-colored notepaper. The good paper. He looked at Danny in the doorway. Danny was watching him with the gray-green eyes that were too old for 8 and too honest for any age, and the expression he wore when he was waiting for his father to catch up to something he had understood already. "She said she hoped it resolved the way it deserved to," Ray said. "Yeah," Danny said. "She didn't know when she wrote it. She wasn't sure it was the same case." "I know," Danny said. "She just hoped." He looked at his father. "That's different from knowing. She hoped for us." Ray folded the letter along its creases. He handed it back to his son. He looked at the dish towel in his hand for a moment, and then he set it down on the counter. "Can I tell you something?" he said. Danny came further into the kitchen and sat down at the table. "Yeah." Ray sat down across from him. He thought about how to say what he wanted to say in the language that was right for an 8-year-old, which was not simpler language he had learned, but more honest language, stripped of the qualifications and hedges that adults used to make difficult things manageable and which Danny had always found more confusing than the difficult thing itself. "For a year and 2 months, Ray said. "I was afraid that doing everything right wasn't going to be enough, that the people with more money and more lawyers were just going to outlast us." He looked at his hands. "I'm good at not showing that kind of thing. You probably didn't know." "I knew a little," Danny said. Ray looked up. "Not the specific details," Danny said carefully. "But I could tell there was something you were carrying that was heavy." He was quiet for a moment. "I didn't say anything because I didn't want to make it heavier." Ray looked at his son for a long time. "You've always paid attention," he said. "You taught me to." The kitchen was quiet. Outside, the December night had settled in fully, the streetlight at the corner of Carver making its usual pale orange bloom on the window glass. From somewhere down the block, a dog was barking at something that turned out not to require continued barking and then stopped. "I need to do something," Ray said. "I need to figure out how to not about the case. That's done. But there's something that needs to happen that I don't quite know the shape of yet." Danny looked at him. "Because of the 40 cents. Because of everything," Ray said. "Because of how it happened. Because a woman who could have looked the other way didn't, and it wasn't connected to the case, it was just connected to you being short at a lunch counter and somehow." He stopped. He tried again. "Some things in the world are connected in ways you can't plan for and can't predict and can't repay in the ordinary sense." He looked at Danny. "But I think you can acknowledge them. I think acknowledgement matters." Danny considered this. "Like a thank you note," he said. "Like a thank you note," Ray agreed. "But bigger." Danny was quiet for a moment. "What kind of bigger?" Ray shook his head slowly. "I don't know yet. I need to think about it." He looked at his son. "But I wanted you to know I'm thinking about it. Because it started with you. The wave. The letter. All of it started with you noticing the right thing and doing something about it." Danny appeared to sit with this. He had the look he wore when he was deciding whether a thing was worth accepting or whether it required more examination. After a moment, he seemed to determine it was the former. "Okay," he said. He picked up the letter from the table. He took it back to his room. Ray heard the desk drawer open and close. He sat in the kitchen for a while longer, in the quiet of the house on Carver Street, thinking about what it looked like when something that had been broken for a long time was finally whole, and what you did with the wholeness once you had it, and how you made it mean something beyond yourself. He didn't have the answer yet, but for the first time in 14 months, he had the space to look for it. There was a man in Clarksville named David Park who had run a nonprofit called the Clarksville Legal Aid Collective for 11 years out of a 2-room office on 2nd Street, 3 blocks from the courthouse. David Park was 53 years old, the son of Korean immigrants who had opened a dry cleaning business in Nashville in 1978 and worked every day of their lives with the specific, unshowy intensity of people who understood that the thing between them and the life they were building was their own continued effort. He had gone to law school on a scholarship, worked for 8 years at a firm in Nashville doing corporate transactional work, and woken up one morning at 41 in his parking garage before a very ordinary Tuesday and understood with uncomplicated clarity that he was not doing the right work. He had given notice that afternoon. The Clarksville Legal Aid Collective served residents of Montgomery County who could not afford legal representation in civil matters, family law, housing disputes, employment cases, personal injury claims that insurance companies were making difficult on purpose. The office had 2 full-time staff attorneys, a rotating roster of volunteer attorneys from the county bar, and a waiting list that David kept on a whiteboard because he could not bring himself to put it in a spreadsheet, which would have made it feel like a number rather than a collection of specific people in specific situations. Ray found him through Cheryl Abbott, who had been referring clients to the collective for 6 years and who had told Ray, when he called her to ask if there was somewhere he could put some of what had come back to him, that David Park was the person she would call. Ray made an appointment. He drove to 2nd Street on a Wednesday morning in the 2nd week of December and sat across from David Park in a small office with a whiteboard on one wall that had 23 names on it and explained, in the straightforward language he used for things he considered straightforward, what had happened, what he had, and what he wanted to do with part of it. David Park listened without interrupting. He was a compact man with reading glasses and the careful, attentive expression of someone who has spent 11 years listening to situations that required being heard accurately before anything else could happen. When Ray finished, David said. "What kind of part are we talking about?" Ray told him the number. David looked at him steadily for a moment. "That's significant." "The procedural cost award was additional," Ray said. "I don't need all of it." He thought about this for a moment. "My truck's been replaced. My wrist is what it is. Danny's got what he needs for now." He paused. "What I need is to put some of it somewhere it does what it's supposed to do." "Which is?" Ray thought about the whiteboard with 23 names on it. "Keep someone else from spending 14 months grinding through something they shouldn't have had to grind through," he said. "Keep someone from getting to the end of their rope because the other side has more rope." David nodded slowly. "There's something else," Ray said. He had thought about how to say this part for several days and had not found a cleaner version than the direct one. "There's a judge in this county. I can't explain the full details of why without it's complicated. But I want to do something in her name, or in recognition of what she did. Not connected to my case." He paused. "She watched an 8-year-old be 40 cents short at a lunch counter and she put 2 quarters down. I want that to mean something beyond the 40 cents. David Park was quiet for a moment. "You want to create a fund," he said slowly, "in recognition of a judge who made a decision in a cafeteria that had nothing to do with her professional role." "Yes. And you want it to serve people who are where you were 14 months ago. People who are doing everything right and getting ground down by the other side having more resources," Ray said. "Yeah." David looked at the whiteboard. He looked at Ray. He had the expression of a man who has been doing this work long enough to have seen most of the ways people arrive at the idea of helping others, and who is making a private and specific assessment of which kind of arrival this is. "Leave me your number," he said. "I need to think about structure. Come back Friday." Ray came back Friday. By the end of that meeting, the shape of the thing existed. A dedicated subfund within the collective's existing 501(c)(3) structure, seated by Ray's contribution, designated specifically for personal injury plaintiffs in Montgomery County facing documented pattern of delay litigation by well-resourced defendants. Not a large fund by the standards of institutional philanthropy, but large enough to matter, large enough to change the calculus of 14 months for someone who had reached the point where they were considering giving up simply because the giving up was less exhausting than continuing. The fund needed a name. Ray drove home that evening and sat at the kitchen table while Danny did his homework and thought about the woman in the gray wool coat and the shepherd's pie and the 2 quarters and a wave. He thought about what she had said to Danny's letter. "I hope your father's case resolved in the way it deserved to. Not I hope you won. Not I hope you got what you were owed. The way it deserved to." That phrase had been sitting with him since Danny read the letter aloud. The specificity of it. The distinction between getting what you wanted and getting what was right, which were not always the same thing and which Eleanor Voss, in 22 years of circuit court work, had understood as the fundamental question of her professional life. He picked up his pen. He wrote 2 words on the notepad in front of him. He looked at them for a long moment. Then he called David Park. The 2 words were, "deserved to." David Park was quiet on the phone for a long moment when Ray told him. "The deserved to fund," he said, turning it over. "It's what she wrote," Ray said. "In the letter to Danny. She said she hoped the case resolved the way it deserved to. Not the way we wanted it to. The way it deserved to." He paused. "That's the whole thing, isn't it? That's what legal aid is supposed to be. Not winning. Just getting to the outcome that was always supposed to happen." David was quiet for another moment. Then he said, "I've been doing this for 11 years, and nobody has ever named a fund that well on the first try." Ray almost smiled. "I had good material to work with." The paperwork was finalized in the 2nd week of January. The Deserve to Fund became an official designated subfund of the Clarksville Legal Aid Collective, seated at an amount that David Park told Ray quietly would cover full legal representation for between 8 and 12 plaintiffs in extended civil matters, depending on complexity. The fund's stated purpose was specific and plain, written in the direct language Ray had insisted on, to provide legal resources to plaintiffs in Montgomery County civil cases where documented pattern of delay litigation by well-resourced defendants has created an unreasonable burden on the plaintiff's ability to pursue a legitimate claim. There was no press release. Ray had not wanted one. David had agreed that the fund would be announced through the collective's existing network bar association contacts, referral attorneys, the courthouse administrative office without ceremony and without Ray's name attached in any public way. The contribution was anonymous. The name was not. Cheryl Abbott called him the morning the announcement went out. David told me, she said, I want you to know that I have sent 8 people to that office in 6 years who needed exactly what you just made possible. A pause. And I want you to know the name is right. It's exactly right. Ray thanked her and hung up and went to work. He did not think about what came next because he had not planned for there to be a next. He had done the thing that needed doing. The rest was not his to manage. He was wrong about there being no next, but he did not know this yet. Eleanor Voss learned about the fund on a Thursday morning in late January, the same way she learned about most things that happened in the Montgomery County legal community through her clerk Damon, who had a comprehensive and finely calibrated sense of what his judge considered worth knowing. Damon put the collective's announcement on her desk with the morning mail. He did not say anything about it. He did not need to. She read it between a 9 o'clock motions hearing and an 11 o'clock bench trial. She read it once, quickly, the way she read things on first pass. Then she read it again, slowly, the way she read things that required her full attention. The deserved to fund. She sat with that for a long time. She thought about the letter on the cream-colored notepaper. She thought about 12 sentences and good paper and a best pen and a child who had said the way she had done it, putting the quarters down without making it a whole thing, had been the right way. She thought about the word deserved, which she had written in a short paragraph to a boy on Carver Street, and which had traveled from her notepaper through the mail and into the hands of a man she had never met, and which had come back to her now as the name of something permanent. She was not a woman who cried at her desk. She had cried exactly once in 22 years of this work, on the day a case involving a child had concluded in a way she had known was correct but had found no comfort in. She had cried then, alone with the door closed, for approximately 4 minutes, and then she had opened the door and continued. She did not cry now, but she sat very still for a longer time than she usually sat still in the middle of a working morning, and she felt something move through her that she did not try to name or organize, but simply let be what it was. 2 quarters. A wave. A letter on good paper. A word she had chosen because it was the most precise word for what she meant. And now a fund that would carry that word forward into the lives of people she would never know, in cases she would never see, for outcomes that deserved to happen and now had a slightly better chance of happening because a man on Carver Street had decided that what came back to him should go somewhere it would keep doing what it was supposed to do. She picked up her pen. She thought about writing something. She put the pen down. There was nothing to add. The thing was complete. Her part in it had been 2 quarters and a wave, and the rest had been Ray Reeves and his son, and the rest after that would be the people whose names would appear on David Park's whiteboard and come off it again when the fund made the difference. She went to her 11 o'clock. But she thought about it for the rest of January and into February, and she thought about it on a particular Tuesday morning when she looked at her docket and saw a name she recognized, a single mother in a housing dispute with a property management company that had filed 3 continuances in 8 months, and she thought, quietly and with the focused attention she brought to everything she considered worth thinking about, that case is going to the collective. She called David Park herself, which was unusual enough that David was briefly uncertain how to respond, and told him she was referring a case, and that the plaintiff might benefit from knowing about the deserved to fund specifically. David Park said he would take care of it. She thanked him and ended the call and went back to her morning. This was the part no one would see. This was the part that would not be in any letter or any announcement or any document filed with the court. A judge making a phone call on a Tuesday morning because 2 quarters had landed somewhere they mattered, and she understood now, with the clarity that the past year had given her, that the appropriate response to something landing right was to keep it moving in the right direction. The meeting happened in March. It was not planned, or rather it was planned in the loose, approximate way of things that both parties want to happen but are uncertain how to arrange without making it larger than it needs to be. Cheryl Abbott had spoken to David Park, who had spoken, carefully and without pressure, to Ray, who had thought about it for 2 weeks and then said yes, and David had handled the logistics with the same quiet efficiency he brought to everything. It was a Saturday morning. The collective's offices on 2nd Street were empty except for David, who let them in and then found somewhere else to be with the tactful instincts of a man who understands when his presence is the extra thing rather than the necessary one. Eleanor Voss arrived first. She was wearing the gray wool coat. Ray noticed this immediately and then felt the specific sensation of a detail confirming itself. Danny had been right, of course, but there was still something in the confirmation that landed differently than the knowing. She was smaller than he had imagined from the courtroom. That was always the way he had found with people who carried significant authority. They were always smaller in person than the authority suggested, which made the authority itself somehow more remarkable, the evidence that the quality came from inside the person and not from the size of them. She looked at him with the same directness he had felt from the bench in January, the quality of someone who sees the actual thing rather than the surface of it. "Mr. Reeves," she said. "Judge Voss," he said. They shook hands. Her grip was firm and brief and honest, the handshake of a woman who has done it thousands of times and has never made it into a performance. Danny was beside Ray in his navy hoodie, a new one, because the old one had finally given up the ghost in February, and his new sneakers, which did not require electrical tape and which he wore with the quiet satisfaction of someone who appreciates a thing working the way it is supposed to work. He was looking at Judge Voss with the focused, unself-conscious attention he brought to things he considered worth understanding. Eleanor Voss looked at him. She looked at him the way she had looked at him across the cafeteria in November, with the directness that was not unkind, the attention of someone genuinely interested rather than performing interest. "You wrote a good letter," she said. "Thank you," Danny said. "You wrote a good one back." Something shifted in her face. Not quite a smile, something quieter than a smile, the expression of a person recognizing something they were not expecting to find. "I tried to match the quality of the original," she said. Danny appeared to consider whether this was accurate. "I think you did okay," he said, with the generous critical assessment of someone who has standards but is capable of acknowledging work that meets them. This time she did smile. It was a small smile, contained and genuine, the kind that arrives without being invited. They sat at the table in David's small conference room, the four of them: Ray, Danny, Eleanor, and David, when he returned with coffee and one glass of orange juice, which Danny accepted with the dignity of a person who has been offered the right thing. The morning light came through the window facing 2nd Street and made the room warmer than it was. Ray had thought about what he wanted to say. He had thought about it for 2 weeks and had arrived, as he usually did when he thought carefully about something, at the simplest version. "I needed you to know," he said to Eleanor, "that the fund is named what it's named because of what you wrote to Danny, not because of the case, because of the word you chose." He looked at his hands. "I've been thinking for months about what the right word for it was, what the whole thing was actually about, the case, the 14 months, what it felt like when it finally went the way it was supposed to go. And you had already written it. Deserved to." He looked up. "That's it. That's the whole thing." Eleanor was quiet for a moment. "I want to be clear about something," she said. Her voice had the same quality it had in the courtroom, measured, precise, and genuinely meant. "The case was decided on its facts. The 2 quarters had nothing to do with it, and I want you to understand that clearly and believe it, because it's true." "I know that," Ray said. "I know you know it," she said. "I want to say it plainly anyway, because it matters that we both hold it correctly." She paused. "What I placed on that counter was not a transaction. It was not an investment. It was 2 quarters because your son was 40 cents short and I was standing there with the 2 quarters and the option of using them." "That's what I told Danny it was," Ray said. Eleanor looked at Danny. "What do you think it was?" she asked him. Danny looked at her steadily. He had the expression he wore when a question was worth taking seriously. "I think," he said slowly, "it was someone choosing to notice." He thought about this for a moment. "Lots of people were in that line. They could all see I was short. You were the one who noticed in a way that did something about it." He looked at the orange juice glass. "I think noticing and doing something are both choices. Most people do one or the other. You did both." The room was quiet. Eleanor Voss looked at this 8-year-old boy in his new navy hoodie and felt, again, the thing she had felt in the cafeteria, the specific quality of a person who is simply being themselves without performance or agenda, and the rarity of it and the value of it in a world that spent a great deal of energy on the opposite. "Your son," she said to Ray, "understands something that takes most people considerably longer to work out. He's been ahead of me on most things since he was about 4, Ray said. Danny appeared to accept this as accurate without comment. They talked for another hour. Not about the case, true to what David had told Ray and what Ray had understood. The case was the past and its resolution was complete and there was nothing left in it. That needed discussion. They talked about the fund, about David's whiteboard and the names that came on and off it, about what 14 months of procedural delay actually looked like from inside it, which Eleanor listened to with the focused attention of a judge who had seen the paperwork and now wanted to understand the person inside the paperwork. She told them, carefully and in the considered language of a woman choosing what to share, about the past year, the cancer, the treatment, the careful optimism of the doctor who did not make promises he couldn't keep but was genuinely pleased to be delivering good news. She told them not because she told most people she didn't, but because it was relevant to the thing they were actually talking about, which was what it meant to pay attention to the moment you were in, to the person who was 40 cents short in the line in front of you, to the word that was the most precise word for what you meant. I came to that cafeteria to watch my granddaughter say 4 lines, she said. I stayed because I was warm and the street was cold. I stood behind your son because I was standing behind your son. She looked at Danny. None of it was designed. And yet here we are. Here we are, Danny agreed, in the tone of someone finding this assessment satisfactory. When they stood to leave, Eleanor shook Ray's hand again, the same firm, brief, honest grip. She shook Danny's hand too, which she did formally, the way you shake the hand of someone you are taking seriously, and Danny shook back with matching formality, which Ray observed with the internal combination of amusement and fierce pride that had been his constant condition since approximately Danny's 2nd birthday. At the door, Danny turned. Judge Voss, he said. She paused. I hope you keep getting good news from your doctor, he said. She looked at him. I intend to, she said. He nodded, satisfied, and went through the door. Ray followed his son out into the March morning, which had decided, in the way of Tennessee March mornings, to be genuinely warm for one day, thin sunlight but real warmth in it, the first warmth of the year that felt like a promise rather than a coincidence. The street was quiet. A truck went past. Somewhere down the block, a door opened and closed. Danny walked beside him toward the parking lot with his hands in his hoodie pocket and the expression of someone who has been somewhere and is integrating the experience before deciding what to do with it. That was good, he said finally. Yeah, Ray said. It was. She's the right kind of person, Danny said. This was his highest category. Ray had learned over 8 years that Danny's assessments of people were binary and accurate. There were people who were the right kind, and people who were not, and the distinction was always about whether they noticed and did something or chose the easier thing of looking away. She is, Ray said. They reached the truck. Ray unlocked it. Danny got in and buckled his seatbelt with the automatic precision of someone who does not need to think about it, which was itself one of the small accomplishments of parenthood that Ray had never stopped privately appreciating. Ray sat in the driver's seat for a moment without starting the engine. He thought about September 17th, 18 months ago. A red light on Highway 41A. The impact that had come from nowhere, from behind, from a man who had been warned not to drive and had driven anyway. The fractured wrist. The totaled truck. 3 weeks of missed work and a case that had ground through 14 months of everything the other side could throw at it. He thought about Danny at the kitchen table reading the court letter with the focused attention of a child who considered things worth understanding fully. He thought about cream-colored notepaper and good paper and best pens. He thought about a whiteboard with 23 names on it and a fund that might someday clear some of them faster than they would have cleared otherwise. He thought about 2 quarters on a lunch counter in November. He thought, the smallest things. He thought, you cannot know, putting 2 quarters down, what they will become. You cannot know, writing a word because it is the most precise word for what you mean, where that word will land. You cannot know, paying attention to an 8-year-old in a lunch line when looking away would have cost you nothing, what you are actually doing. You can only know that you had the choice and you made it, and something followed from the making that you could not have predicted and did not earn the right to predict, because it belonged to the sequence of events that begins when one person decides to notice and does something about the noticing, and then another person decides the same thing, and the sequence goes where it goes, into spaces and outcomes and funds named for words and children who understand things earlier than expected, and March mornings in Tennessee with actual warmth in them. He started the truck. Pizza, Danny said. It's 10:30 in the morning. Rosario's opens at 11. Ray pulled out of the parking lot onto 2nd Street. We can drive around for 25 minutes, he said. Danny settled back in the seat with the satisfaction of someone whose plan is proceeding correctly. They drove through Clarksville in the March morning, past the courthouse on Commerce Street with its limestone permanence, past the diner and the hardware store, past Maplewood Elementary where the schoolyard was empty on a Saturday and the bare oak tree at the corner of the fence had small new buds on it that you had to look carefully to see. They drove down Carver Street past the house with its kitchen light and its desk drawer with 2 letters in the back of it, the cream-colored and the good paper, which Danny kept there because he kept the things he considered worth keeping, which had always been, and would always be, the right things. They drove until 11 and then they got the good pizza and they ate it at a table by the window and Danny explained to Ray the entire 3rd episode of the migration documentary in detail Ray had not requested but found he genuinely wanted. And the Tennessee sun came through the glass and was warm on both their faces, and the day continued in the ordinary, uncomplicated way of days that have already done something important and are content now to simply be themselves. Outside the restaurant, on the quiet March Street, the world went on in all its unreliable and occasional rightness, doing what it sometimes did when the right people made the right choices at the right moments, which was simply to keep moving forward, carrying everything forward with it, all the 40-cent kindnesses and the precise words and the deliberate waves and the letters on good paper and the funds named for what things deserve to be, carrying it all forward into the lives of people who hadn't been born yet and cases that hadn't been filed yet and lunch lines where someone would be short and someone else would be standing there with the option of 2 quarters and the choice of what to do with them. Carrying it forward the way kindness always carries forward, which is quietly, without announcement, further than you can see from where you put it down. Thank you so much for watching until the end. If you loved this story, check out the other videos on your screen now. I think you'll really enjoy them. And don't forget to subscribe if you haven't already. See you in the next story.